She was aggressive, she was uncooperative. She reached into her jacket before I could identify myself as a law enforcement officer.
And you felt threatened?
I did, yes.
Officer Dale Mercer said it the way he said everything on the stand, evenly, with the practiced calm of a man who had testified 43 times in 11 years, and understood that the performance of certainty was more persuasive than certainty itself. The prosecutor nodded. And you felt threatened? I did, yes. And that's why you detained her. That is correct. The woman at the defense table looked at the witness stand. She was 36 years old. She was in a gray blazer. Her hands were folded on the table in front of her, completely still. She had been charged with resisting arrest and obstruction of justice following a traffic stop on the evening of March 14th. Officer Mercer had pulled her over for a lane change he described as erratic. He had alleged that she had reached toward her jacket in a manner he perceived as threatening, that she had refused to identify herself, and that she had physically resisted when he attempted to secure her. The body camera footage had malfunctioned. There were no independent witnesses. It was her word against his. Mercer smoothed his collar and looked at the jury with the expression of a man who has never once in his life been on the wrong side of a room. What he did not know, what the prosecutor did not know, what the jury did not know, what no one in that courtroom knew except the woman at the defense table and two people in an office building across the city, was that the woman he was lying about on the stand had spent the last 14 months building the case that was going to end his career, and that the folder containing that case was, at this exact moment, sitting in a locked drawer in her desk at the Georgia Bureau of Investigation. Stay with this story. Subscribe, because what happens when that folder opens is not something Dale Mercer was prepared for by 11 years of being believed, and it is not something you will forget easily. But to understand that moment, you have to understand both of the people in that courtroom, not the surface of them, what built them. The Delwood Police Department served a mid-sized suburb outside Atlanta that had grown quickly enough over the previous decade that its institutions had not kept pace with its population. The department had 62 officers. It had a civilian review board that met quarterly and had not, in its 6-year existence, sustained a single complaint against a sworn officer. Dale Mercer had been with the department for 11 years. He was 40 years old, solid through the shoulders, with the specific bearing of a man who had been told, consistently and from a young age, that authority looked like him. He had grown up in Delwood, the son of a deputy sheriff, who had served the county for 26 years, and whose photograph hung in the department's hallway alongside 3 other officers who had received the department's service commendation. He was not, by the department's metrics, a problem officer. His use of force rate was within the departmental average. His arrest record was clean in the sense that mattered to the department. Convictions, or pleas, or charges that disappeared quietly before they became records. His supervisor, a lieutenant named Gary Holt, who had known Dale's father and had been at the department for 22 years, described him in his annual evaluations as reliable, professional, and well-regarded by the community. What the annual evaluations did not capture, because the annual evaluations were not designed to capture it, and because the Civilian Review Board had not sustained a single complaint, and because the specific mechanism by which the thing existed required all of those conditions simultaneously, was the pattern. The pattern was in the complaint files, not the sustained ones, the dismissed ones. 14 complaints in 11 years, each one reviewed and closed, each closure signed by a different supervisor, no single person ever having read all 14. The complaints had a shape. They came from a specific geography. The eastern residential neighborhoods that had grown fastest in the last decade, that were most demographically mixed, where the gap between who had lived there for 20 years and who had arrived in the last 5 was most visible. They came from specific kinds of stops, lane changes, rolling stops, equipment violations so minor they were nearly pretextual. They described a specific sequence: a stop, an escalation that the officer had initiated, an arrest that required the person to have behaved in a way that justified it. 14 people had filed complaints describing that sequence. 14 complaints had been dismissed. The 15th had not been filed. The 15th was a woman who had been pulled over on March 14th, charged with resisting arrest and obstruction, and brought to trial in a courtroom where Dale Mercer was now sitting in the witness stand and saying she had reached toward her jacket in a threatening manner. Her name was Daria Elise Okafor, and she had not filed a complaint. She had done something else entirely. Daria Okafor was born in Columbus, Georgia in 1987, the only child of a public defender named Joseph and a pediatric nurse named Grace. In a household where the law was not an abstraction, but a daily, specific, contested reality, the thing her father spent every working hour trying to hold to its stated principles and finding, consistently, that the distance between what it said and what it did was the most important terrain in any case. She had been a precise child, not quiet precise. She asked questions that went one level deeper than the question most people asked, and she held the answers she received up against other information she had, and she noticed when they did not align. Her father had recognized this quality at 8 years old and had not tried to discourage it, because he understood from his own career that the ability to notice misalignment was not a problem. It was the most useful tool a person could carry into a room where power was being exercised. She had gone to Georgia State on a criminal justice scholarship. She had graduated third in her class. She had joined the GBI at 24 as a junior investigator and had spent 12 years building a record that was, by any measurable standard, the kind of record that made her supervisors speak about her in the specific, slightly competitive way of people who know they are describing someone who is going to exceed the ceiling above them. She was thorough, she was patient. She had the specific, disciplined quality of an investigator who understood that the work of making the invisible visible was not dramatic. It was archival, systematic, and slow, and it required you to follow the document trail past the place where most people stopped, because most people stopped when the document said the thing was resolved, and she had learned. In 12 years, that resolved and true were different things. She had been assigned to the GBI's Law Enforcement Integrity Unit 14 months ago. The unit was small, 4 investigators, a supervisor, and a director who had come from federal civil rights enforcement, and who had spent 20 years learning that the hardest cases were not the ones where wrongdoing was hidden, but the ones where it was in plain sight, and everyone had agreed, through the specific mechanism of not looking, to keep it invisible. The unit had opened a file on the Delwood Police Department 8 months into Daria's tenure, based on a referral from the state attorney general's office. The referral had contained 3 items: a statistical analysis of traffic stop data showing a demographic disparity in the department's eastern district, a copy of the 14 complaint files, and a note from an assistant attorney general that said, "This has the shape of a pattern, but no one has read it whole yet." Daria had read it whole. She had been reading it whole for 6 months when Dale Mercer pulled her over on March 14th. She had been coming home from a late night at the office. Not in an unmarked vehicle. She drove her own car off duty, a 4-year-old Accord, nothing that identified her as law enforcement. She had made a lane change on Route 17 to avoid a pothole she had driven past 100 times and knew was there. The lane change had been legal. She had checked her mirror. She had signaled. The blue lights appeared 40 seconds later. She had known, in the specific, immediate way of a person whose professional life involves understanding what these situations mean, exactly what was happening. She had been in those complaint files. She knew the geography. She knew the time, 10:40 at night. She knew what a stop that began this way, in this part of the district at this hour, was statistically likely to become. She had kept her hands visible. She had spoken calmly. She had provided her license and registration when asked. When Mercer had asked her to step out of the vehicle, she had reached toward her jacket pocket for her GBI credentials, because she was, in fact, a law enforcement officer. And identifying herself as one was both her right and her professional obligation. He had not let her finish. What happened in the next 4 minutes was what 14 other people had described in 14 complaint files. She had been cuffed. She had been placed in the back of the patrol car. She had told him her name, her agency, and her badge number. He had looked at her and said, "You can say whatever you want. Right now you're going to the station." She had said nothing else. She had a phone. She had made one call from the back of the patrol car when Mercer was outside filing the incident report. She had called her supervisor. Her supervisor had said, "Are you all right?" She had said, "I'm fine. Don't pull me out of this. I need to see how it goes." Her supervisor had been quiet for a moment. Then he had said, "Daria, he's going to charge you." She had said, "I know." Let him, and that was the thing Dale Mercer never saw coming. What was at stake was not Daria's record. She would not be convicted. She was a 12-year GBI investigator with a clean record and a supervisor who had documented, within an hour of her arrest, the circumstances under which it had occurred. The charges would not hold. What was at stake was what happened next. The GBI's Law Enforcement Integrity Unit had 6 months of documentation on the Delwood PD. They had the 14 complaints. They had the traffic stop data. They had the demographic analysis. They had 2 witnesses from previous stops who had agreed to give sworn statements. What they did not have, what every internal affairs investigation needed and almost never got, was a direct, documented, witnessed instance of the pattern occurring in real time. To a witness whose credibility could not be challenged, whose account was corroborated by her own agency, and who had been a law enforcement officer for 12 years. What they had not had, until March 14th, was Dale Mercer doing what he did on the record, in front of an agency that had already been watching him. Daria had understood this from the back of the patrol car. She had understood it with the specific, professional clarity of an investigator who had spent 6 months reading 14 complaints and had, on a Tuesday night on Route 17, become the 15th. She had told her supervisor, "Don't pull me out, let him charge me, let him testify. Let him say on the stand under oath exactly what he says in those complaints." Her supervisor had said, "If he does that," she had said, "then we have everything we need." 3 weeks. The trial had been scheduled 6 weeks after the arrest. She had retained a private defense attorney, not because the GBI hadn't offered representation, but because she needed the proceeding to look exactly like what it was. A black woman, alone, in a courtroom in Delwood, facing an officer whose word had beaten 14 other people's words in less formal settings. Her attorney was a woman named Carol Reeves, who had been practicing criminal defense in Atlanta for 22 years, and who had read the case file in 2 hours and called Daria back and said, "You want him to testify?" Daria had said, "Yes." Carol had said, "You want him to say all of it?" On the record, under oath, "Yes." Carol had been quiet for a moment. "You know I'm going to cross-examine him." "I know. And you know that if he's as practiced as you say, he's going to hold the story." "He's going to hold the story," Daria had said. "That's fine. I need the story on the record, not the outcome, the story." Carol had understood. She had prepared her cross-examination with the specific, architectural precision of a lawyer who understood that this was not about winning the trial. It was about creating a record. 11 days before the trial, Daria had met with her supervisor and the director of the Law Enforcement Integrity Unit in a conference room in the GBI's Atlanta office. She had laid out the timeline. The arrest, the trial, the testimony, and what would come after. The director, a man named Harold Washington, who had spent 20 years in federal civil rights enforcement, and who had, in those 20 years, seen the inside of this specific situation more times than he could count, had listened without interrupting. When she finished, he had said, "You understand that if you're wrong about how he testifies, I'm not wrong," she had said. "You're not wrong about the pattern. You might be wrong about the man. People surprise you." She had looked at him. She had said, "He has done this 14 times. He has never once changed his account. He believes the account. That's why it works. He will say exactly what he said in every other case because in every other case, the account was sufficient." Washington had looked at the folder on the table. The 6 months of documentation, the 14 complaints, the demographic data. He had said, "All right, what do you need from us?" She had said, "Subpoenas ready." The moment he finishes testifying, he had nodded. Done. 6 days. The false hope came 4 days before the trial. The prosecutor's office contacted Carol Reeves with a plea offer. Reduced charges, time served, a fine. Carol had called Daria immediately. Daria had said, "No," Carol had said, "Daria. It's a clean exit. I don't want a clean exit. If we go to trial and he holds the story, he'll hold the story. I told you that. The conviction isn't the point." Carol had been quiet. Daria had said, "Carol, I need his testimony on the record. I need him to say, under oath in a court of law, what he did on March 14th. That is what the investigation needs. That is the thing that has been missing from 14 cases. A sworn account from Dale Mercer in which he describes what he actually does and calls it proper procedure." A long silence. "You're using your own trial," Carol said. "Someone has to stop him," Daria said. 14 people tried. This is how we do it." Carol had accepted no plea. The trial was on a Thursday. The prosecution presented its case in the morning. Mercer testified at 11:15. He was good. Daria had known he would be good. She had read the transcripts of his testimony in 3 previous cases, 2 of which had resulted in convictions, and she had understood from the transcripts exactly what Carol was going to be working against. He was calm. He was specific. He used the language of the use of force training manual without sounding like he was reciting it. He described the threat he had perceived in the language of professional assessment. The jury watched him the way juries watched officers who testified well, with the specific, provisional trust that people extend to authority when authority is presented competently. He finished. The prosecutor sat down. Carol Reeves stood. She began the cross-examination the way she began everything, without apparent urgency, with the specific patience of a person who knows exactly where she is going and is in no hurry to get there faster than the record requires. She asked about his training. She asked about the departmental use of force policy. She asked him to describe the lane change that had initiated the stop. She asked him what he had observed in the 30 seconds between the lane change and activating his lights. His answers were clean. Daria watched them from the defense table and noted each one and thought, "Good, keep going, say all of it." Then Carol asked, "Officer Mercer, in your 11 years with the Delwood PD, how many times have you filed an incident report citing passenger obstruction or resistance?" He thought about it. "I'd have to check the exact number, approximately, perhaps 8 or 10 times. 8 or 10, Carol made a note. "And in those 8 or 10 cases were the individuals ultimately charged?" "In most cases, yes. And in most of those cases the individuals were black." The prosecutor was on his feet. Objection, relevance. The judge, a woman named Patricia Sims, who had been on the bench for 14 years and who had heard, in those 14 years, every version of every objection to this specific type of question, sustained the objection. Carol moved on. She asked about the body camera malfunction. He explained the technical failure calmly, as if he had explained it before, which he had in a previous case, 2 years earlier, when his body camera had also malfunctioned. Carol noted this without comment. She simply asked, "Is it common for your body camera to malfunction? Equipment failures happen. In your 11 years. How many times has your body camera malfunctioned during an incident?" A pause. "I'd have to check. More than twice, possibly." Carol looked at her notes. She said, "Officer Mercer, the defendant reached into her jacket. You've testified to that." "Yes." "You perceived that as a threatening gesture." "Yes." "Before you could identify yourself as a law enforcement officer." "You said, that's correct." "And at what point in the stop did you identify yourself?" "When I approached the vehicle." "You identified yourself before asking for license and registration." "Yes." "So you had already identified yourself as a law enforcement officer before she reached into her jacket." A fractional pause. "I identified myself." She may not have heard clearly. She may not have heard. That's possible. And is it also possible that she was reaching for identification because you had identified yourself as a law enforcement officer and she was responding to that identification? "I perceived it as threatening." "You perceived it?" "Yes." If you need to see what happened next, subscribe. Because what Carol Reeves placed on the witness stand record in the next 4 minutes, not through argument, but through questions, is the reason Dale Mercer's testimony exists in the public record in the form it does, and it is the reason what happened after the trial happened the way it did. She placed 3 things into the record through his answers. First, that he had identified himself before she reached, his own words, his own correction buried in the qualification. She had not argued the point. She had simply asked him to confirm it in 4 different ways, each time receiving an answer that moved fractionally closer to the truth of what had happened, because each answer was trying to stay consistent with the previous one, and the previous ones had established a sequence he could not fully walk back. Second, that his body camera had malfunctioned on more than one previous occasion during an incident. His own admission, vague enough to be deniable, specific enough to be documentable. Third, that his use of force incidents were concentrated in a specific period, the Eastern District, the last 4 years, since a reorganization of patrol assignments that had placed him in that geography exclusively. She had not argued any of it. She had asked questions. His answers had built the record. She sat down. The jury deliberated for 2 hours and 20 minutes. They returned a verdict of guilty on the obstruction charge, not guilty on resisting arrest. Daria looked at the verdict. She looked at her hands on the table. Carol leaned toward her. "Daria, it's all right," she said. "You were convicted." "I know." She looked at the jury, at Mercer, who was speaking quietly with the prosecutor, at the judge, who was reviewing her notes. She said, "He testified to everything I needed him to testify to, under oath, in a court of law, in the public record." She picked up her legal pad. She looked at what she had written during the cross-examination, not notes on the trial, but a different list. Timestamps, quotes. The exact moments where his testimony aligned with the pattern in the 14 complaints. The exact moment where his account of identifying himself before she reached created an internal contradiction he had tried to paper over with. She may not have heard. She folded the legal pad. She said, "Call Washington." The subpoenas were served the following morning, 3 of them. To the Delwood Police Department's Records Division, to the department's body camera maintenance contractor, and to Officer Dale Mercer personally, requiring production of all documents related to traffic stops conducted in the Eastern District between 2020 and the present. They were served at 9 in the morning. By 9:40, Mercer's attorney had called the department's legal counsel. By 10:15, the department's legal counsel had called the city attorney. By 10:45, the city attorney had called the GBI's director. Harold Washington had taken the call in his office. He had listened to the city attorney's opening position, that the subpoenas were overbroad, that the investigation appeared retaliatory, that the department intended to challenge the production requirements. Washington had said, "Counsel, I'd like you to know something before we continue. The investigator who was arrested on March 14th is assigned to my unit. She has been building this case for 14 months. The arrest did not create the investigation. The arrest is the most recent documented instance of what we've been documenting for 14 months. The subpoenas are not overbroad. They are specifically tailored to the conduct we have been reviewing. And the testimony your officer gave yesterday under oath has been incorporated into the evidentiary record of an active GBI investigation." A silence. "What kind of investigation?" the city attorney said. Washington said, "Asterisk, the kind that has 14 prior complaints, a demographic analysis of traffic stop data, 2 witnesses with sworn statements, and now a sworn court record of the officer describing, in his own words, the conduct that is the subject of the investigation." Another silence. "Longer, when were you planning to inform the department?" "I'm informing you now," Washington said, "through the appropriate channel." "Which is this call?" The documents were produced without further challenge. Daria sat in her office on the Friday after the trial and opened the folder. Not the investigation folder, that was in a separate system, locked and procedurally secured. This was a smaller folder. Her personal working folder, the one she kept notes in, the one where she recorded the shape of a case as it developed, not the evidence but the architecture of it, the way one thing connected to the next. She had started it 14 months ago with a single question, written at the top of the first page: "Who has been here before?" 14 complaints. She had read every one. She had found the shape. She had built the documentation. She had been on her way home from a late night doing that work when Dale Mercer had pulled her over on Route 17. She looked at the folder. She thought about the 14 people who had filed complaints, about what it had cost them to file, the specific cost of standing up in an official process, and saying "this happened to me," and then receiving a letter that said "insufficient basis for further action," about what they had not known, that 14 other people had stood in the same place and received the same letter, and that the letters were sitting in a filing system that no single person had read whole. She had read them whole. She picked up her phone. She called her father. Joseph Acaffer picked up on the second ring. He was 71 years old and had been a public defender for 33 years, and had retired 3 years ago, and was, by his own accounting, exactly as busy as he had always been. Just differently. "How did it go?" he said. "Guilty on the obstruction," she said. A pause. "I'm sorry." "Don't be," she said. "He testified to everything." Her father was quiet for a moment. "You're going to appeal," he said. "Eventually. First we're going to use what he said." "How long until the investigation is complete?" 6 to 8 weeks, maybe less." He was quiet. She could hear the specific silence of a man who had spent 33 years in courtrooms and understood, without needing it explained, what she had done and what it had cost and what it was going to produce. He said, "Asterisk, your mother wants to know if you're eating." She laughed. "A real one." "Tell her yes," she said. "She won't believe me." "Tell her I'll come for dinner Sunday." She hung up. She sat at her desk for a moment. Then she went back to work. The GBI's Law Enforcement Integrity Unit released its findings 8 weeks later. The report was 47 pages. It documented 14 complaints, the pattern of stops, the demographic disparity, the body camera malfunction history, and the sworn testimony from the March trial, including the specific contradiction in Mercer's account of when he had identified himself. It recommended termination of Dale Mercer's employment. It recommended a review of all 14 closed complaints for potential reconsideration. It recommended a structural audit of the department's complaint review process. It was referred simultaneously to the State Attorney General's office and to the Delwood City Council. Mercer was placed on administrative leave the day the report was released. His attorney issued a statement saying he would contest the findings. The department's statement said it took the report seriously and was committed to due process. Harold Washington held a press conference. He was brief. He described the investigation in the general terms appropriate to an active matter. He did not name Daria. He did not describe the March arrest. Daria watched the press conference from her office. She had not held a press conference. She had not issued a statement. She had not spoken to any journalist who had called the GBI's communications office in the weeks since the trial. She had gone back to work. Carol Reeves filed the appeal of the obstruction conviction the week the report was released. The appeal was based on specific errors in the jury instructions and on newly available evidence. Specifically, the GBI reports documentation of Mercer's pattern of conduct, which was directly relevant to the credibility of his trial testimony. The appeal was granted 4 months later. The conviction was vacated. Daria received the notice in an email. She read it. She forwarded it to Carol with a one-line reply, "Thank you." She went back to work. The thing about 14 complaints is that each one had a person behind it. Daria had read the complaints as documents, the dates, the locations, the specific language of each account. But behind each document was a person who had stood in a process that had told them their account was insufficient, who had driven a different route afterward, or had stopped driving at night, or had told their children something specific about what to do if it happened to them. Daria had not been able to give those 14 people back what had been taken from them. The report would not undo their experiences. The investigation would produce accountability for the institution, which was a different thing from justice for the individuals. And she had known that distinction going in, and had carried it through every month of the 14. She wrote letters, not official communications, personal ones, on her own time, on her own stationery. 14 letters to 14 people whose names were in 14 complaint files. The letters said what had happened, not in legal language, in plain language. They said that their complaints had been read, and that they had been believed, and that what they had described was real, and that the documentation of what they had described had been part of what had made the investigation possible. She did not promise them anything. She did not tell them the system had worked. She told them what was true, that they had stood up individually in a process that had told them individually that they were insufficient, and that the record of their standing up had existed in a filing system, and that someone had finally read the whole of it, and that it had mattered. She sent the letters. She received 7 responses. One of them was from a man named Devin Carver, who was 26 years old and had filed his complaint 4 years ago and had received his closure letter 11 days later and had driven a different route ever since. His letter said one thing. It said, "I didn't think anyone read those." She read it at her kitchen table on a Sunday evening. She held it for a moment. Then she wrote back. She said, "I read them. All of them, every one." Dale Mercer's termination was finalized 3 months after the report. His attorney contested it through the departmental grievance process. The grievance was denied. He appealed to the Civil Service Commission. The Civil Service Commission reviewed the GBI report and the trial testimony and the body camera malfunction history and the 14 complaints and denied the appeal. He was 40 years old. He had been with the Delwood PD for 11 years. He had testified 43 times. He had been believed 43 times. The 44th time, the person he had testified against had been building the case that ended his career for 14 months before he put her in handcuffs. The departmental complaint review process was restructured. The new process required a cross-referencing review of all complaints against a single officer to be conducted automatically at the 3rd complaint. The review was mandatory, not discretionary. It was assigned to a supervisor who had not previously reviewed the complaints being cross-referenced. The structural gap that had kept 14 complaints invisible to any single reviewer was closed. It had been open for at least 11 years. Daria ran 4 miles every morning. She had run 4 miles every morning since she was 22 years old. When a training instructor at the GBI Academy had told her that the body's discipline and the mind's discipline were the same discipline, and she had believed him and had not stopped. On the morning after the Civil Service Commission's ruling, she ran her 4 miles on the path along the reservoir outside Atlanta that she had been running for 6 years. The path was familiar enough that her feet knew it without her thinking about it, which left her mind free to do what it did on the runs, not plan, not process, but simply be present in the motion. She thought about Devin Carver driving a different route. She thought about 14 people who had filed complaints and been told they were insufficient. She thought about a man on a witness stand who had believed his own account so completely that he had walked into her cross-examination with the full confidence of someone who had never once been challenged, who had given 43 performances of the same testimony and had never been made to feel the weight of it, and who had, in the 44th, provided a sworn account of his own conduct that he had not understood, was the last piece of something 14 months in the making. She ran. The reservoir was still in the early morning. The path was wet from the previous night's rain. The air smelled like earth and water, and the specific, clean coldness of a Georgia morning in March. She thought about her father, who had spent 33 years making the same argument, that the distance between what the law said and what it did was the most important terrain in any case, and that someone had to stand in that terrain and measure it, carefully, without flinching from what the measurement showed. She had been measuring it for 14 months. The number was 14 complaints, 47 pages, 8 weeks, 1 trial, 1 appeal, 1 vacated conviction, 1 termination, 1 restructured complaint process. That was the measure. She ran to the end of the path and back. She went home, she showered, she made coffee. She sat at the kitchen table for a moment with her hands around the cup and looked at the morning coming in through the window. Then she went to work. There was a new file on her desk. She opened it. There is a kind of patience that is not passive. It is the patience of someone who has decided that the work matters more than the acknowledgement of the work, who reads 14 files when 11 would have been sufficient, who sits in a patrol car in handcuffs and calls her supervisor and says, "Don't pull me out, let it go to trial," who watches a man lie about her on a witness stand and writes down, on her legal pad, not notes about the trial but the timestamps and the exact quotes that are going to become part of the evidentiary record of the case that will end his career. It is the patience of someone who understands that the truth does not always announce itself in the moment it becomes true. Sometimes it becomes true in a filing system, in a cross-examination, in a letter that a man reads at his kitchen table and writes back to say, "I didn't think anyone read those." Daria Akhafer read all of them, every one. Here is the question this story leaves behind. What is sitting in a filing system somewhere, in your organization, your community, your own life, that has been dismissed 14 times and is waiting for someone to read it whole? And what would change if you were that person? If this story stayed with you, share it, because the people who need it are not going to find it on their own. Subscribe, stay close. The next one is already coming, and it starts the same way, with someone being told their account is insufficient, and ending the same way, with someone who read the whole of it. Drop a comment. Tell me, who in your life has done the work that nobody saw, quietly, patiently, without recognition, because they believed it mattered? Let them be seen, even here, even now. Because everybody deserves to be seen. Golden Truth Tales, Script 15. A cop lied in court to ruin a black woman. He had no idea she was the detective investigating him. Words, minutes, all characters, institutions, and events are entirely fictional.